Hello, everybody. Jennifer Schaus here. We are coming to you live today from Washington, D.C. as we continue in our webinar series covering the DFARS, which is the Defense Federal Acquisition Regulation Supplement. Thanks for joining us. And just a couple pieces of information about the series. Our webinars are held on Wednesdays and Fridays. They're all complimentary. You can find all of the recordings over on our YouTube channel. We actually have a DFARS playlist. But there are 750 plus webinars on government contracting topics. So if you're ever looking for something to do or need some help falling asleep, that would be your spot to go. If you're looking for any of the 700 plus corresponding PowerPoints, those are found over on slideshare.net. You can log into SlideShare with your LinkedIn credentials and it won't cost you anything. We do have sponsorship and advertising options available. If somebody sent you the link today to register for the DFARS webinar series and you want to register for more, if you hop over to our website, click on the tab that says the DFARS, you'll find that on the left-hand side, we actually covered the DFARS back in 2021. This is, we'll say, a living, breathing document or regulations that have gone through changes since 2021 and are continuing to evolve. So just keep in mind, if you jump ahead to any of the parts that we have yet to cover, when you're looking at the 2021 recordings, some of that data and information may have changed. On the 2025 column on the right-hand side, you've got registration links for anything that we've yet to cover and recording links for anything that we've already covered. A little bit about us. We do provide services for established government contractors. Most of them are listed here. Others are found on our website. Our primary focus is helping companies get onto and maintain the GSA schedule. We also help with modifications, audits, renewals, a little bit of everything there, as well as the VA schedule. In light of the recent executive order, if any companies are interested in getting onto the GSA schedule, which will now be one of the main contracting hubs, at least on paper, and as things continue to evolve, we are here to assist. You can drop us an email at hello@jenniferschaus.com. In the event that your company is selling to federal contractors, we've got some advertising options available for you, including event sponsorship. And speaking of events, we do have one coming up on June 23rd, which is about 2 weeks away. It's on a Monday night. The federal government agencies and departments that will be there that have confirmed their attendance are listed here on the screen. You got 3 from DOD, as well as NASA, SBA, and the VA. So the link to get tickets is there at the top of your screen. If you've got questions, drop us an email. Here's some stats just in the event that you want to advertise in our newsletter. We now reach over, I just looked at the number today, was 38,303 subscribers, most of which are government contractors. Okay, we want to thank our in-kind sponsors. Govevents.com is the go-to platform for posting events related to government and government contracting. You can find all of our events, webinars, and recordings over on govevents.com. The Fairfax County EDA, Economic Development Authority, has an online calendar of events and webinars happening in the DC metro area. Visit Fairfax County EDA for more information. Set Aside Alert is the go-to publication for posting events, for finding opportunities related to small women-owned, veteran-owned, hub zone, and 8A opportunities. Visit setasidealert.com for more information. The Virginia Apex Accelerator is a trusted resource and DLA, Defense Logistics Agency funded organization. They provide local training, counseling, and mentoring for aspiring government contractors, as well as matchmaking events. If you want to sell to state, local, or federal governments, please contact your local Apex Accelerator. You've got training links to the training calendar, free resources, and you can also schedule an appointment with your Virginia Apex Accelerator counselor today. Okay, we also want to thank our paid sponsors, which is what allows us to put this series on for free. Our friends over at BidSpeed, they will be with us actually on June 23rd at the networking event. The BidSpeed platform allows users to search public sector opportunities at the federal, state, and local level. Users can also find anything from a compliance matrix to teaming partners, incumbent point of contacts, expiring contracts, and proposal templates. Discover, manage, and secure government contracts with BidSpeed. BidSpeed is an official partner of the SBA's ETG Empower to Grow program. Contact BidSpeed today. If you are thinking about competing for contracts with Department of Defense, you need to prepare for CMMC. That's the Cybersecurity Maturity Model Certification. C3 suite of CMMC solutions include C3 Command, C3 Catalyst, and C3 Core. These solutions answer the needs of every defense contractor, whether your CMMC priority is a fast defined path to compliance, or you need the flexibility to manage multiple environments. C3 offers solutions. C3 is your partner with the deep expertise in IT, cybersecurity, and compliance. Contact C3 today or visit their website. WorkPlan. WorkPlan is an online contract management and accounting tool designed for federal contractors and hosted by Amazon Web Services. Get and stay DCAA compliant, manage expenses, timekeeping, and forecasting. Plus, use the WorkPlan platform to manage your capture process and your CRM. Contractors can integrate their HR and payroll into this one easy-to-use solution. Contact WorkPlan today. Ateria. Ateria specializes in Microsoft Cloud licenses and services for government and contractors. Ateria provides a business advantage for Microsoft Government Cloud licensing, managed IT administration and security, as well as data intelligence services and solutions. They implement secure, compliant, and scalable solutions to enhance operations, reduce risk, and uncover opportunities. Contact Ateria for expert IT assistance. Okay, last but not least, we want to thank our friends over at Gov White Papers. Gov White Papers is the central hub for government and government contractors to find and post content geared towards solving public sector challenges. With your free membership, you can add relevant white papers, case studies, data sheets, and more, making your content available to a wider government audience. Do you have the expertise but not the content? Gov White Papers can also create materials to meet your specific needs. Join for free today at govwhitepapers.com. Okay, we are here today to cover the DFARS Part 233. I took a peek at the slides. We've got Maria Panichelli. She's a fantastic speaker, and I'm going to stop talking and turn it over to Maria, who's going to cover DFARS Part 233, Protest, Disputes, and Appeals. Maria, the floor is all yours, and thanks for joining us.
Well, thank you very much, Jen, for that introduction. As you guys have heard, my name is Maria Panichelli. I am a partner with the law firm of McCarter and English. McCarter is a full-service law firm, so we've got about 400 attorneys spread across a number of practice areas, from corporate law to IP to general litigation to environmental. But my group, the Government Contracts and Global Trade Group, focuses exclusively on government contracts and global trade. I'm on the contract side of things, and I help contractors all over the country of various sizes and working in all industries, basically through every step of the procurement process. As you guys know, if you're in the industry, there's any number of issues that can come up either in connection with a specific procurement or a specific contract that you are working on, or just by virtue of being a government contractor in general. So I help clients with all manner of things. Some of my biggest practice areas are bid protest litigation, both on the protester and on the intervener or defense side, claims litigation, CDA claims, as well as REAs, as well as kind of the counseling about how to prepare for or hopefully try to pre-negotiate and avoid having to do claims. I do a lot of subcontracting work, again, both on the prime and on the subcontractor role for federal projects, dealing with negotiation and drafting of subcontracts, dealing with pass-through claims, dealing with subprime disputes, dealing with Miller Act claims, you name it, I'm probably involved. Do a lot with the small business programs, so eligibility analyses and size and status protests, things like that. But also the perennial favorite, teaming, joint venture, and mentor protege, which I'm sure you guys are all very familiar with. And then finally, kind of a grab bag that I generally call performance and compliance counseling, but that includes all of those miscellaneous things that you need to worry about when you're a contractor. So things like Buy American compliance or cost principles compliance, cybersecurity, suspension, debarment, OCIs, all of the things that kind of go into being a federal government contractor. Obviously, recently, a lot of the work has been in relation to suspensions or stop work orders or terminations for convenience, due to the various administrative things that have been going on. So I kind of run the gamut. So I'm very familiar with protests and with CDA claims and appeals. We're going to be specifically talking, as you heard, and as you know if you signed up, about DFARS Part 233, which obviously is part of the Department of Defense, FAR supplement or supplemental acquisition regulations, and the ones that specifically deal with protests, disputes, and appeals. Next slide, please. So we're going to go through, much like the FAR itself, the DFAR is divided up into two different sections under 233. Number one deals with bid protests, and number two deals with disputes and appeals, or otherwise known as claims under the CDA, the Contract Disputes Act. One of the things that you should know kind of going in, for those of you who aren't familiar, when you're talking about the whole regulatory system here, the way that the FAR is set up is that you've got parts 1 through 51 that kind of outline different topics, whether it's responsibility or small business programs or disputes and appeals or protests. And then you've got sections within those different subsections talking about, here are the contracts clause that are supposed to be used. And then at part 52, you've got all of those clauses. Now, that's the overall FAR, the Federal Acquisition Regulation that applies to all executive agencies, subject to very limited exceptions. And obviously, if you're a legislative agency, it's a little bit different. You're not subject to the FAR. But then individual agencies or kind of departments, here obviously we're talking about the Department of Defense and kind of all of the various services they're under. So the Army, the Navy, the Air Force, etc., have supplement or can have supplemental acquisition regulations. So things like the DFARS we're talking about today, but also things like the GSAR or the VAR if you're talking about the VA. So the way that the structure works is that the FAR is the baseline, right? That's what everyone needs to follow. And the supplements, like the DFARS, can't contradict or conflict with the FAR, but what they can do is kind of add to it or add a gloss or kind of add a wrinkle. And that's what we're going to be focusing on today. We're going to be talking about the things in the DFAR, specifically DFAR Part 233, that kind of add some additional information or some additional nuances or kind of tweak things that are in FAR Part 33. The other caveat or kind of global comment I want to make up front is, for those of you who are in this industry, you probably know, it's been pretty hard to avoid the news, that there is, at least from what we have heard, a major rewrite or quote unquote overhaul of the FAR going on. The exact parameters of that are a little unclear at this point. Obviously, it's forthcoming. We're expecting to know more in the coming months. And whether or not some of the supplemental acquisition regulations like the DFAR are also going to be changed, and the extent to which they're going to be changed, I guess we'll have to see. So, we're doing this presentation June 6th, 2025. We're talking about the state of the law as of June 6th, 2025. But be aware, if you're listening to this or if you're coming back and thinking about this later, there might be some changes depending on what has been overhauled in the interim period. Next slide, please. So we're going to start talking about the first piece of DFAR 233, which is the protest piece. So 233.1 is the piece that deals with protests. We're going to talk about point 2, dealing with Contract Disputes Act, quote unquote disputes and appeals, in a little bit. The 4 differences or nuances or wrinkles that are added as part of this section of the DFAR relate to 4 different things. The first is that it adds a little bit of gloss or further information, a little bit of a tweak to the timing rules relating to bid protests, and specifically, or at least primarily, at the GAO, the Government Accountability Office, which is an independent agency of the legislative branch, but it is one of the forums where you can file a bid protest if you are a protester. So these rules are going to apply, when you're talking specifically about a protest against a DoD agency. That's when the DFARS are applicable, right? They're only applicable to Department of Defense procurements. The second piece that's a little bit different is the limitations that DFARS 233 puts on protests regarding IT procurements. There are certain authorities that government agencies can follow, and if they follow those authorities and do so properly, they're kind of immunized or shielded from potential protests, specifically in the IT realm, and we're going to talk about that a little bit. The other two are more administrative requirements that the government needs to follow, but it's important that contractors be aware of them. And those are kind of reporting or briefing requirements for certain types of acquisitions. Specifically, if you're talking about big acquisitions, like massive acquisitions over 1 billion, or that have been characterized as really important to the agency, there has to be a kind of upper level reporting structure so that people higher up in the chain are aware of those protests. And then there are some reporting requirements relating to protests that have been filed in multiple forums. So like I said, the GAO is one forum, but protesters can go to the agency, can go to GAO, can go to a court of federal claims. At least in most cases, when you're dealing with task orders, it's a little bit different. You can only go to GAO and only over certain dollar amounts. But you've got a choice of forum. And when you're on the protester side, you can actually, go to the agency first. If you don't like the answer you get, go to the GAO. If you don't like the answer you get, go to the court of federal claims. But that doesn't necessarily mean everybody does that. And it's not technically an appeal. Each has the ability to kind of adjudicate protests separately, but the government has a kind of a reason to want to keep track of protests that are filed both at the GAO and Court of Federal Claims. So we're going to talk about that a little bit more when we get to that section as well. Next slide, please. All right, so just a quick overview of bid protests, and I kind of alluded to this on the last slide, but like I said, the DFAR provides additional considerations and issues regarding bid protests, but it doesn't change the FAR, what the FAR says in Part 33, and it doesn't necessarily change the GAO rules themselves, which are at 4 CFR 20 and a bunch of the regulations kind of in sequence following that, or the Court of Federal Claims bid protest procedural rules, which are in Appendix C of the Court of Federal Claims rules. So there are a lot of different moving pieces here, as those of you in the industry are probably very familiar with when you're talking about government contracting. The rules kind of come from different places. So when you're talking about bid protests, you're talking about looking at the substantive law, which is going to include the FAR and the Supplemental Acquisition Agency regulations, in this case, the DFAR. And you're talking about looking at the forum rules, so the GAO rules or the Court of Federal Claims rules, and kind of all of those things together are going to govern the trajectory and the processes and the procedures and the deadlines and things like that. But as I said before, protesters have a choice where they're going to file a protest, at least as a general rule. They can go to the agency, that's an agency level protest when you file with the contracting officer. They can go to the GAO, the Government Accountability Office or Comptroller General. That is a body that does a number of things, including publish certain types of fraud reports. Their OIG, or Office of Inspector General, does investigations into certain types of fraud. Obviously, the GSA runs, some of the purchasing through their own. I'm sorry, the GAO, does reports on the GSA purchasing. And runs kind of their own evaluation of that. But one of the major things the GAO does, and obviously it is most known for doing, is kind of famous for, or the default body for, is bid protests. So you've got administrative attorneys there that function as judges, that are GAO attorneys, that kind of rule on the cases that protesters file. The other option, though, other than the agency or the GAO, is the Court of Federal Claims. This is a trial level court. For those of you who are more familiar with our judicial system, this is the equivalent of a United States District Court. The District of Delaware, or the Eastern District of Pennsylvania, or the Southern District of New York, or the Eastern District of Texas. These are the trial level federal courts. Many of those across our nation are, as the names I just rattled off would seem to indicate, geographically based, but we do also have courts that are subject matter jurisdiction based, and that is what the Court of Federal Claims is. So two of the components of cases that the Court of Federal Claims hears are related to government contracts. The first is bid protests, what we're talking about right now. The second is claims, which we're going to talk about later today. They also hear things relating to certain veteran benefits appeals. They also have some issues relating to tax. They also have some issues relating to patents that fall under their jurisdiction. But for government contractors purposes, they are, one of the venues for protests, and they are one of the venues or forums, I should say, for CDA claims as well, in addition to the applicable boards of contract appeal. So the protesters have a choice to go to these three places unless they have a task order protest. In that case, only the GAO has jurisdiction, and there are different monetary thresholds that apply. But we're still, even within the DFARS 233, context, working within this framework that's established by the FAR, by the CFR, the 4 CFR 20, and sequence rules relating to the GAO, and or Appendix C relating to the Court of Federal Claims. But as we're going to see in a slide or two, there are some wrinkles, like I said, that the DFARS adds, or things that you need to be aware of, or additional requirements that you need to kind of keep in mind when you're talking about a protest against a Department of Defense agency, such that the DFARS comes into play. Next slide, please. So when we're talking about protests, these are divided up into two different categories, and this is recognized in the DFAR as well as in the FAR, and as well as the rules relating to the GAO forum and the Court of Federal Claims forum. And it's really important whenever you're talking about anything relating to protest, whether it's the DFAR or any of the other stuff I just listed off, to understand, because if you're going to successfully navigate the protest process and be compliant with all of the layers of regulations that you need to be compliant with, you need to understand what type of protest you're bringing. And there are a number of different things that come into play. What section of the FAR is the procurement at issue being procured under? What's the dollar amount involved? But one of the biggest one is kind of where you're at in that trajectory of the source selection process. Are you all the way at the beginning where the solicitation just dropped and the protester is challenging the terms of the solicitation or other actions that the agency may have taken, at the very early stages? These are pre-award protests. You can also have a pre-award protest that comes, maybe a little bit later than the solicitation dropping, but something like someone gets kicked out of the procurement because it's a multi-phase procurement and they don't make it, they're deemed unacceptable on phase 2, so they don't make it to phase 3. Obviously, there's no award yet, but there has been kind of a whittling down or a narrowing down. That might still, and you should always consult a legal professional to figure out exactly where you're at in the process. That might still be considered a pre-award protest. But even pre-award protests are kind of divided up into subcategories. Is it a protest against the solicitation, alleging that there are errors in the solicitation? Or is it a protest alleging that something happened, like, removal from the competitive range, or getting rejected while people were down selected, or things like that? All of that category is kind of in contrast to, or in comparison with, post-award protests, which are, I think, at least in my experience, what a lot more contractors are familiar with, and what a lot of contractors assume is the case whenever they hear about a bid protest. They assume that there's been an award and someone is challenging the award. But bid protests, there's actually, a much wider variety than a lot of contractors think. But the key here is, learning to distinguish between pre-award protests, like I said, that challenge the terms of solicitations, or maybe the down select decisions that really shape the procurement going forward, versus post-award protests where you're challenging, the things that led up to the award decision, but the award decision itself. And in that case, because you have an awardee, or potentially awardees, plural, if there was multiple awards made, you've got people on the other side. It's not just the government stepping in to defend their award. You potentially have those awardees joining the fight as interveners to help defend the decision and hopefully maintain or keep their award. This is the framework that kind of, like I said, follows through everything all the way from the FAR down to the DFAR that we're talking about today. And it's important to understand some of the distinctions or nuances that DFAR 233 draws. Next slide, please. So now we're getting into these differences. So you'll see the section we're dealing with is protests after award. Again, that's why it's important to understand the difference between protests before award and protests after award, because the biggest nuance here, the little wrinkle that is encompassed in FAR 233-104 is a difference relating to GAO protests, and specifically a difference relating to GAO protests after award, those post-award protests. And what it says here is, in lieu of the time periods set forth in FAR 33-104C1. So again, you see this reference to the FAR 33, and we're talking about the DFAR 233, which supplements that. It's saying, hey, don't use the time periods that are outlined in FAR 33. We're going to give you some new timelines, and we're going to get to what that is in just a second. But basically, they're going to say, in the new timelines we give you under DFAR 233, not the timelines in regular old FAR, we've got some different obligations that contracting officers need to follow. And specifically, that's going to relate to the suspension of performance, or quote unquote stay. When you file a protest, when you're on the protester side, if you meet certain deadlines, there's a deadline just to be considered timely, but there's an extra special and sometimes earlier deadline. And if you meet that earlier deadline, you can get an automatic stay, which is basically the equivalent of a big red pause button being put on the procurement at issue. Well, why would you want that as a protester? Why wouldn't you want that as a protester? You're trying to fight over, hey, you gave the award to, Bob over there, but I should have gotten the award. I don't want Bob to start, performing the work while we're arguing over who should be performing the work. So a lot of times protesters, it's really important to get that automatic stay. That is something that is outlined in CICA, the Competition in Contracting Act, which is a statute, but then also, like I said, always moving pieces, working together, outlined in the FAR. And then here we see the DFAR saying, well, yeah, but if you're dealing with the Department of Defense agency, things are just a little bit different. Contracting officers have to immediately suspend performance or terminate the awarded contract, task order, or delivery order if a protest is filed within these time periods. And then they go on to talk about the time periods being a little bit different than the time periods in the FAR. Next slide, please. So what are the differences here? Well, they're similar to the automatic stay that is talked about or spoken of, or the outlined in FAR 33-104, but it's more specific because it references task and delivery orders, not just contracts. So we've got this idea that, within 5 days of the day of the debriefing, you are able to get a stay. And that is the same across all of these, across the FAR and the DFAR. You also have within 5 days, and this is new from the DFAR, this is not in the FAR, within 5 days after a debriefing date was offered to the protester under a timely debriefing request. What that means is it makes it a little bit harder for the protester to meet this requirement. Basically, what it says is, if you're a protester and you ask for a debriefing and you're offered, June 6th, and you say, I can't take that, can we do it next Monday? The agency might say, sure, we could do it next Monday. And under the general rules and the FAR and the CICA stay, you would have 5 days from the day you get your debriefing, with the exception of some stuff we're going to talk about a little bit later on the enhanced debriefing topic. But what this is saying is, no. If you've been offered an earlier debriefing, regardless of whether you reject it, if you do not basically take that first requirement or first offered debriefing, you might kind of already be in your 5-day period. We're not going to hold off until you get your debriefing. This can be a tricky issue. It's been interpreted different ways. It's definitely something you should talk about with your attorney. But the lesson here is, especially when you're dealing with defense agencies, you don't want to postpone as a general rule, because it just gets you in, even if it doesn't, ultimately end up with you, shortening your deadline. It gets you into a whole debate about it. You really just don't want to even venture into that dangerous territory. If you're offered a debriefing date, take it. The other thing that is more specific or a little bit nuanced here is that the FAR and CICA talk about, if you're not talking about a post-award protest, you're talking about, I'm sorry, if you're not talking about a required debriefing protest, because not all protests require a debriefing. It's then just a deadline of 10 days of the contract award. But here there's an extra piece that says within 10 days after the date of the award for a task order or delivery order. So it gets a little bit more specific. It's a little bit more fulsome than the FAR. Doesn't really necessarily add that much from a substance point of view, but it's more of a clarity thing. The other thing that kind of is tacked on there, though, is that only applies where the value exceeds 25 million. And this marries up with some other requirements. Remember that I said the GAO only has, GAO is the only place that has jurisdiction over task order protests. So that's kind of coming into play here. And then furthermore, even to get jurisdiction at the GAO, you've got certain dollar amounts that you need to reach. Well, remember, we're talking here about the DFARS. So we're talking about Department of Defense. We're talking about military versus, non-military versus civilian, whatever you want to call it, agencies and work. With defense contracts, that threshold is 25 million, and it's set to potentially go up in another year or so. But task orders under 25 million, generally, unless they meet very limited exceptions, can't be protested. If you're dealing with a civilian agency, it's a little lower. It's a $10 million threshold. But this kind of invites that concept into another area, talking about the stay itself. So again, it adds the idea that you are not just talking about contracts, you're talking about task orders or delivery orders thereunder, but it also incorporates the concepts relating to the threshold, the jurisdictional threshold, by saying, hey, this only applies to procurements over 25 million. Now, for those of you who are familiar with the stay, you'll know that under CICA and under FAR 33104, there is an override of the stay in situations where the government feels like, hey, I know that the protester filed in enough time to get the stay, to get that big red pause button, but for matters of national security or for other reasons that are really important and compelling or in the best interest of the government, we're basically saying we have to, in this case, override that stay. We need to let the awardee start performing, even while we're arguing over why, and who should be performing. That's rare, but it happens. Most of the time when it happens because, like I said, it's an emergency contract, like, nursing services, and you can't just have no nurses working, while you figure it out, or it's something relating to national security that kind of can't be left in the lurch while a protest is pending. But you also see it in other situations. I actually have a protest right now where an agency overrode the stay just because it was really important to keep everything on track. It's a project that's important to the agency, and they just don't want it disrupted in the meantime. So you'll see it for all sorts of reasons. The DFAR does not change that. It's, what the DFAR says is, yeah, these CICA stays are still subject to an agency override, provided that the government jumps through the hoops that they're supposed to jump through in terms of, conducting the necessary analysis and doing the necessary paperwork to do the CICA override. Just provides the agencies the abilities to do it upon a written determination by the quote unquote head of the contract activity. And then again, they need to notify the GAO of that override. The GAO doesn't really have to approve it. The protester's remedy would be to challenge that in a separate protest at the Court of Federal Claims, which sometimes happens. But the DFAR here, it doesn't really change that aspect of things from the FAR. It's all consistent. There's a CICA override. The government needs to jump through certain hoops to get it. They need to give notice of it to the GAO. And then if the protester, has a problem with the override of the stay, they challenge it separately at the Court of Federal Claims. Next slide, please. So again, I went over these, but this is the actual language from the DFAR. Within 10 days after the date of contract award, or within 10 days after the date, and this is what's new, which, what isn't in the FAR, after the date of the award of a task order or delivery order where the value exceeds 25 million, incorporating that jurisdictional threshold. Next slide, please. Or if you're talking about a required debriefing situation, within 5 days after the debriefing date is offered to the protester, or within 5 days after a post-award debriefing is concluded. But note, and this is just a little preview of where we're going to go next, note that the debriefing has to be concluded in accordance with, FAR 15506, which is the section talking about for negotiated procurement, the post-award debriefings, what you do and don't get, and also in accordance with DFAR 215-506-70, which is another section of the DFAR. Next slide, please. And I should note that the way that this regulation is written is we're talking about whichever of these four is the latest. So, you need to file as a protester, within the time periods we just went through, those four different prongs, whichever is later. All right, so moving on, I said, we just previewed a little bit what we want to talk about. Now, strictly speaking, this is not part of FAR 233, or I'm sorry, DFAR 233. It's part of DFAR 215, but it's incorporated by reference based on the requirement that we were just reading, right? The idea that, okay, you've got to file within 5 days of a debriefing once it's concluded, but that needs to be concluded in conjunction with FAR 15506, and specifically in connection with the DFARS 215-506-70. For those of you who have been in the industry for a while, you might remember that several years ago, and post-COVID, I'll be honest, all the timelines run together at this point. I think we're talking about like 2016, 2017, if memory serves. But there was this big push for enhanced debriefing. The idea being, on one hand, our procurement system is a self-policing system. It's important for contractors to be able to protest, and to that end, the more and the better information we give them, the better the system works, because protesters aren't just grasping at straws. They have the information they need to protest where a protest is legitimate. But to those who said, but that's just going to result in more protests and more delays and more problems, the corollary, somewhat counterintuitive, but nonetheless simultaneous answer is, but what will also happen is the more information we give protesters, they might not go on fishing expeditions looking for something that is wrong. They might just recognize, oh, now that I see the full picture, yeah, you're right, I'm dead in the water. This would be a stupid protest to file. So the idea is, if we give protesters or contractors more information as part of their debrief, they are better informed, and that will lead to better decisions, both in terms of hopefully knowing when to fold them and when to walk away, to quote some famous song lyrics. If it's a dead protest, if the agency, by sharing more information, shows that there's really no basis to protest, and then the corollary is, or if the agency actually did something wrong, if the protester has more information, that's good. Then the protest happens. That's what's supposed to happen to guard the integrity of the procurement process. So there was this push for enhanced debriefing, and the place that it kind of made the most headway is in the Department of Defense space. So new rules were enacted that talk about the fact that agencies need to provide, as part of the debriefing process, additional information. Over certain dollar thresholds, they have to give basically a redacted version of the source selection document to the protesters as part of the debriefing. But perhaps most importantly, and what really ties back into what we're talking about today, is this idea that protesters should be allowed to ask follow-up questions. And that's what this section deals with. And what happened is, all the way back, and again, I want to say it was like 2017-ish, they issued kind of a memorandum, a DoD memorandum. Then there was a DFAR deviation, and then finally it was codified into the DFAR. Again, albeit strictly speaking, not at 233, but incorporated by reference into 233, and very, very relevant for what we're talking about. So we kind of need to cover it for 233 to make sense. But there's this idea at 215-506-70 that the contractors have the ability to ask follow-up questions in debriefing. So what this regulation said is that when the agency provides a required post-award debriefing, now there's a little bit of a few things to unpack there. One, note the word required. One of the things I want to, make sure you guys know, and if you've got questions about this, you should follow up with a legal professional, is that despite popular belief, debriefings are not always required. If you are dealing with a simplified acquisition or dealing with something under the GSA schedules or dealing with something that's a commercial items contract or dealing with a sealed bid, the government is not required to give you a debrief. Required debriefings are for FAR Part 15, anything that's under competitive, procurement, under contracting by negotiation under FAR 15, and many task orders under FAR Part 16. Other than that, you can ask for a debriefing. You might get one, but that doesn't mean that it was required. And you might get something, but sometimes contracting officers call things debriefings, and what they really are quote unquote brief explanations. They're different. So it's important when you're dealing with all of this debriefing and protest land stuff to understand, and if you've got questions, to talk to an attorney to figure out, all right, am I in the world of required debriefings or not? Because that's going to impact those deadlines we talked about. The 10 days from award or 10 days from the day of issuance of a task order, those are going to be deadlines that apply if you're not in a required debriefing world. The other deadlines that kind of stem from the debriefing are going to be deadlines that apply if you are in required debriefing world. So that word required, it's one word in this regulation, but it's got a whole bunch of information behind it that you have to understand to properly parse this requirement. The other thing is post-award debriefing. So when providing a required, which we just talked about, post-award debriefing, for that you need to go back to the FAR, specifically FAR 15506, and look at the requirements relating to a post-award debriefing. What that section does is lay out what you do and don't get as part of a debriefing, specifically a post-award debriefing. But the idea here is, when the government has provided one of those, they've gone through, they've figured out it was required, they've given you a post-award debriefing under 15506, then there's this follow-up piece where the contracting officers have to give the contractor an opportunity to submit additional questions. And for those of you who are familiar with FAR 15506, you'll remember that one of the things you have a right to in the debrief itself is answers to relevant questions about whether, contracting authorities and the law have been followed. So, when preparing for a debrief, that's one of the most important things you can do. But sometimes you get a written debrief, right? You don't necessarily have the opportunity to ask questions, although in that scenario, you should always try to give questions in advance when you request your debrief. But here, what this is saying is, all right, even if you got to ask questions during the debrief, even if you submitted questions in advance of a written debrief and then you got a written debrief answering those questions, after we do your debrief, you have 2 business days to ask us more questions. And then we will respond to you. Aspirationally, it's supposed to be 5 days. Most of the time it is, but I've seen it take longer. And basically your deadline for your protest doesn't start ticking until you get those answers. So it extends the time you've got to kind of continue the conversation, gather more information, and then file your protest. So again, going back to the overarching theme here relating to protests, really important to understand the protest world in general, understand the deadlines, understand what debriefing does to those deadlines, and understand what enhanced debriefing does to those deadlines. You can end up with wildly different deadlines to file, both to be timely and to get the stay that we've been talking about. That's kind of more of a nuanced approach or more detailed approach in DFAR 233. Next slide, please. Just to wrap that up, like I said, the post-award debriefing is not to be considered concluded until you get answers to those questions, which is 2 on the slide right now. Note, however, that if you don't ask questions, then the old deadline applies. Basically, the deadline starts ticking as soon as your debrief is concluded. It's only if you pose the questions within 2 business days that you get that extension until they answer your questions. Next slide, please. Don't make that mistake. Some people have just assumed they get the extra time. All right, so the next thing we talked about, the fact that there are certain limitations or kind of a shield that this section gives to certain procurements relating to IT. And the idea here is that there's a reference to another section of the DFAR 239-7305. And the idea is if the government exercises the authority provided in that section, which we'll talk about in just a second, to limit disclosure of information, then no action undertaken by the government under that authority shall be subject to a protest. So this applies to procurements for IT. Basically, it gives the government the ability to shape those IT procurements, specifically with the relation to managing supply chain risk and limiting the disclosure of information. We all know we're living in a world where there are cybersecurity concerns, both I mean that in terms of CMMC and COI requirements and things like that, but also just email hacks and things in general. When I say cybersecurity, spam and phishing attempts and all of those wonderful things that we deal with. But the idea here is that the government can take certain steps to kind of manage that supply chain risk, to limit the disclosure of information, to hopefully protect the government. And if it chooses to exercise that authority, if it chooses to shape these types of procurements in this way, it can't be protested. You can't go to COFC, you can't go to GAO. And again, specifically, it talks about the authority in DFAR 239-7305. This is a broad power, lacks any decisional authority. In other words, there have been no protesters that have pointed to this in any reported protest, but it's something you should be aware of. So I want to quickly touch on the related DFAR section that this is relying on, which is 239-7305. Next slide, please. And this is basically the things, like I said, that the agency can do that are shielded under the authority of 239-7305 from a protest under 233. They can exclude a source that fails to meet qualification standards, quote unquote, for purpose of reducing supply chain risk. Again, remember risk being the important thing. They can exclude a source that fails to achieve an acceptable rating, that rating either with regard to an evaluation factor, providing for the consideration of supply chain risk, again, that keyword risk, in the evaluation of proposals for the award of a contract or the issuance of a task or delivery order. They can withhold consent for a contractor to subcontract with a particular source, again, because of concerns with risk. Next slide, please. They can authorize the agency to limit disclosure of information relating to exclusions to manage supply chain risk. Again, this all relates to managing supply chain risk and limiting information to limit government potential liability or danger to the government, and strips GAO and Court of Federal Claims of bid protest jurisdiction. Notably, agencies also provide limited notice to the affected contractors. This is only supposed to be directed to the extent necessary to effectuate some action. However, notice is to be provided broadly to the other federal agencies. So again, the idea for purposes of DFAR 233 is that if a contracting officer avails themselves of the authority in this section that we just went over, takes any of those actions, they kind of have a get out of jail free card. They can't be protested. These are things that are subject to basically no oversight. The government has decided, hey, look, we've got to give contracting officers more leeway, more wiggle room to exercise their judgment in cases relating to supply chain risk. And the idea that they can really limit disclosure of information to limit supply chain risk to the amount possible, or I'm sorry, to the maximum amount possible. Next slide, please. Now, in terms of the next pieces, remember we talked about 4 things up front. The first 2 we've covered; those are more substantive. These last 2 pieces are more, really just administrative or procedural. These are things relating to reporting requirements. Specifically, DFAR 233-170 talks about this briefing requirement for protested acquisitions valued at $1 billion or more. It refers to something in the PGI, which is Procedures, Guidance, and Information. These are not technically regulations, but they're basically supplemental guides meant to help people understand how to interpret and apply the regulations. And that's what is incorporated here. Side note, one of the debates about the FAR overhaul, or one of the things people are speculating about, is that to the extent that, what we're hearing is a lot of things might be removed from the FAR, the question, well, are they going to be added into a PGI, or are they just going to be removed altogether? And what impact is that going to have? So again, just an interesting side note, or at least interesting for us law nerds. But that's what we're seeing here. We're seeing something that's not codified in the regulation itself. Literally, the regulation just has one sentence that says, follow the procedures at PGI 233-170 for briefing protested acquisitions valued at $1 billion or more. So then you've got to go to that section, this companion resource, to kind of figure out, all right, how am I supposed to interpret this? How am I supposed to apply this? Next slide, please. And what that PGI says is that in the event of a competitively awarded major defense acquisition program, and that's been protested, or the acquisition of services over 1 billion, or I guess I should say at 1 billion or more, then the agency's got to brief DoD leadership. Specifically, that briefing must outline the basis of the protest, the agency's position on the protest, and then any other information the agency deems relevant that might relate to, the risks of, whether or not the protest could be switched to someone else, any concerns they have about that, concerns they have about the timing, about a stay, about the work being stayed in the meantime. But the idea here is, if we're talking about programs that are really important or really expensive to the DoD, the DoD, higher leadership needs to be kept abreast of the fact that there are protests kind of in the hopper. Next slide, please. How do you define, major defense acquisition program? Like I said, short answer, simply put, in common layman's terms, a big, expensive program that's important to the DoD. Longer answer, or more technical answer, is a DoD acquisition that's not highly sensitive classified program, and also has been designated by the DoD as a major defense acquisition program, or meets a certain dollar threshold in excess of 1 billion. So again, it's this idea of, really large, important programs need to be reported up the chain. These programs don't include rapid prototyping acquisitions or defense business systems, which are defined separately in other regulations and statutes that are not part of our purview here today. Next slide, please. The other piece, that's the first reporting requirement in DFARS 233 relating to protests. The second is the reporting under 233-171. And this specifically relates to, remember I said that the idea of dual forums. The procedures here relate to the reporting of information on protests involving the same contract or proposed award when there have been protests filed at both the GAO and the United States Court of Federal Claims. This is another one that cross-references a PGI, so really, really brief in the regulation itself, and then refers you over to PGI 233-171 for what you're supposed to do. Next slide, please. And what that talks about, what that PGI talks about, is that you've got this protest tracker, a web tool on the Procurement Integrated Enterprise Environment, which you can access at the link there. Basically, it's just a bid protest data repository for the DoD. It's there because it's required by statute and it's required by these regs. So when protests are involving the same contract or the same proposed award, no matter what the value is, when there's been a protest filed at both GAO and Court of Federal Claims, whether that's because one protester has gone to 2 forums, or whether that's because multiple people have filed and some went to GAO and some went to Court of Federal Claims. Side note, when that happens, they all get consolidated to Court of Federal Claims, just an FYI. But basically, the gist here is that the contracting officer has to report that outcome of the protest at the Court of Federal Claims so that everyone can kind of be on the same page and that everyone can track it. Next slide, please. So with that, we are moving with our last few minutes from the protest realm in DFAR 233 to the disputes and appeals realm. This is at DFAR 233.2. And again, this supplements FAR Part 33, Subpart 2, that talks about disputes and appeals. The difference between protests, disputes, and appeals, we talked about bid protests. Basically, that's the idea that a contractor is challenging something that went wrong during the procurement process or the award, or even as early as the solicitation itself, about a future award, an award that's coming, or an award that has just been made. The argument is over who should have the award. Disputes and appeals are later in the process, right? A contract has been performed or is being performed, and issues have arisen. There are changes, there are different site conditions, there is something else that went wrong, and the contractor is saying, hey, based on these issues, I'm entitled to more money, or I'm entitled to more time. It's a controversy or disagreement over a contract between the parties that's already kind of started performance. It's basically the equivalent of a breach of contract in other contexts, but because you're dealing with the federal government, it works a little bit differently here. These processes are subject to, like I said, first the FAR, but also the Contract Disputes Act, the CDA, and the DFAR, again, is just kind of adding a little bit of gloss or nuance to these concepts. Next slide, please. So, mentioned this before, Court of Federal Claims is once again one of the forums that, or fora, that contractors can pick. You always have to exhaust your administrative remedy by filing a claim with the agency first. You may or may not elect to file an REA before that, but the claim is what you need to do to kind of trigger your ability to litigate later. You then have the opportunity to choose between the applicable Board of Contract Appeals. In the defense context, that's always going to be the Armed Services Board of Contract Appeals. But for example, if you're dealing with the GSA or the VA or another civilian agency, it would be the Civilian Board of Contract Appeals, CBCA. But you've got this choice in terms of now where am I going to go litigate, Court of Federal Claims or the Armed Services Board of Contract Appeals. COFC, is generally slower. It's a little bit more formal, therefore it can be a little bit more expensive. Another big difference is who the agency is represented by. Counsel on the other side at the Court of Federal Claims is going to be the Department of Justice, whereas if you're at the board, if you're at the ASPCA, it's going to be agency counsel. One of the other differences is the timeline you have to appeal the denial of your claim. So you file your claim with your contracting officer, you hear back, June 1st. You've got a year to go to the Court of Federal Claims. You've only got 3 months or 90 days to go to the board. So, one of the things you always want to talk about when you submit a claim and when you hear back from the government is, what's my best forum? Why would I go to one forum over the other? And that's a discussion you should always have with your attorney. Next slide, please. DFAR doesn't mollify any of that. They do have some references here regarding limitations on payment. For the most part, what you need to take away from that is that this kind of refers back to other statutes talking about the amount of information and the certifications that need to go into a claim and kind of when the government can pay you based on whether you certified things correctly. But generally speaking, claims is an analysis that needs to encompass a lot of different regulations. The FAR, the DFAR that we're talking about, the Contract Disputes Act, and then also the forum rules, much like we talked about with regard to the protests. But here, the piece of the DFARS that you need to understand is that it basically incorporates those other laws to say, hey, look, those are all applicable here, and certification of claims is really important. Next slide, please. This is another section that talks about a PGI or references a PGI. Specifically, this references, and obviously for you guys who are on the contractor side, this isn't anything you need to worry about, but it's something you should be aware of because it's going to inform what might be a good idea for you when you're putting your claim together, because it explains how they're going to look at your claim. And what the PGI 233-210 says is when it would be helpful in reviewing the current claim, contracting officers should get information on claims previously filed by the contractor. Such information should provide or may provide, a historical perspective of the nature and accuracy of the claims submitted by the contractor and how they were settled. So what this means is they're not going to consider when you're at the Department of Defense and this section of the DFARS is applicable as opposed to just the FAR being applicable. You've got this additional consideration you need to think about, and that is your claim is not going to be considered in a vacuum. It's not going to be considered in conjunction with all other claims only if you consolidate them. Rather, they're going to go back and look at the history of your claims. So if you're overly litigious on claims that maybe you have not the best basis for, it's probably going to impact your credibility. If you seem to always be asking for way more money than you ultimately are deemed to be entitled to, probably going to impact your credibility. If you've got a good track record of only claims that are legit and you settle them all and they're all for reasonable amounts, and you've gotten a reputation in those files for being fair in your negotiations, it's probably going to weigh in your favor. Now, theoretically, the law is the law and entitlement is entitlement, but there's always gray area, right? So what this is basically saying is when you submit a claim, contracting officers are going to look at your history, and people are people. So your history is going to play into account in terms of, and this specifically says the nature and accuracy of your claims. So you want to make sure that you understand that this stuff is a cumulative history. You don't want to do anything that's going to hurt your credibility in a claim or in future claims before Department of Defense contracting officers. Next slide, please. The next piece, getting towards the end of DFAR 233, is that it does talk about an alternative use of FAR Clause 52233-1. Now remember, at the very beginning, I talked about the way that the FAR was set up, right? You've got the FAR parts 1 through 51 talking about definitions and then instructions to, in some cases, the contracting officer, in some cases, the contractor. But the idea that's kind of laid out by topic usually talks generally about the applicability of a certain segment of the regulation, then talks about the general procedures or policies, then gives you the clauses that you need to look at. And then in FAR Part 52 are all the clauses. One of the most important clauses is the disputes clause. This goes into every government contract. The idea being this is the clause that governs that you've got to use that Contract Disputes Act that we talked about, and also, importantly for what we're talking about today, governs what happens in the meantime while that is pending. So what this section of the DFAR says is, hey, when the acquisition is for aircraft, spacecraft and launch vehicles, naval vessels, missile systems, tracked combat vehicles, and related electronic systems, and the CEO determines that the continued performance is either vital to the national security or vital to public health and welfare, or the head of contracting activity determines that the continued performance is necessary for pending a resolution of any claim, then you are not supposed to use the regular old disputes clause. You're supposed to use the alternate version. Next slide, please. So let's take a look at what that means. It's not a whole big difference, to be honest. You see the regular version up top. You see the alternate version that the DFARS is telling you to use in those circumstances that we just went over at the bottom. The difference is that it adds that language or relating to. Really what this does is just broaden the clause a little bit. The purpose of this section of the disputes clause is to tell you, hey, just heads up, like while we're arguing about whether you, the contractor, are entitled to more time or more money, while you have this claim in, you have to keep working. You might need to self-finance the work that I told you to do while you're, trying to get reimbursed under that claim. You've got to keep prosecuting the work. This is very different, or at least somewhat different depending on the jurisdiction, than when you're dealing with state, local, education, or commercial or private contracts. A lot of times in those scenarios, you got a little bit more wiggle room to kind of stop work or hold off or say, hey, I'm not moving until we reach an agreement on this topic. No go when you're dealing with the federal government. You could be having the biggest fight ever about the fact that they told you to do A, B, and C, and you originally interpreted the contract to do, X, Y, Z, and it's going to be $5 million extra work, and it's going to be, 6 months extra time. And the remedy you've got is to file a claim and then litigate that claim if that claim is denied. But you have to keep doing the work you were, instructed to do in the meantime. Side note, like not strictly in the topic that we're talking about today, but very, very important clause to pass down to your subcontractors when you're a prime, because if you got to keep going, so do they. But the idea here is, the clause says, and the clause is bigger than this, but this is the important language for purposes of the DFAR deviation, is the contractor shall proceed diligently with performance of this contract pending final resolution of any and all, relief, claim, appeal, blah, 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 blah. What this says is any, relief, claim, appeal, or action arising under or relating to. So it's just an attempt to make that net even broader, to make your obligation to continue performing in light of a fight even more concrete. The takeaway here is you got to keep going, fighting about it on a parallel track. You can't just stop work. You can't walk away. It's very broad. They're making it even broader in this alternative clause. Next slide, please. So again, last piece here is another issue dealing with an additional contract clause, and specifically what DFAR 233-215-70, can't talk with all these numbers, tells you is that, okay, if you've got a situation where we're talking about an overseas contract, we've got to add a different clause. So unlike the one we just went over, which is an alternative clause, this is just an additional clause. And specifically, you're supposed to use the clause at DFAR 252-233-7001, which is the choice of law overseas clause in solicitations and contracts when contract performance will be outside the United States in its outlying areas. So in other words, if you're doing work OCONUS for the DoD, they're going to add this clause in, which specifically kind of just shores up the sense that like you're not going to get away with anything extra just because it's OCONUS. Says, hey, the choice of law very explicitly is still American federal law. Doesn't matter if you're doing the work in Mexico, Romania, or Guam. Well, I guess Guam is the America, but or Japan, Taiwan, whatever you want to say. Also clears up that the forum selection basically says, hey, look, contractor waives its right to invoke the local jurisdiction. In other words, the courts of Romania or Mexico or Taiwan or whatever list I just gave. It specifically says, no, we're still sticking to the agreement. We're going to accept the jurisdiction of the Court of Federal Claims and the ASPCA. The fact that this is overseas really doesn't make a difference to the fact that, we're going to follow the same procedures and go to the same places that we would if it was inside the United States. So again, just an additional clause that the DFARS requires be added. The FAR does not require this be added. This is something unique to the DFARS for overseas contracts. Next slide, please. So remarkably, for a topic that's so important, protests are really important and claims are really important, the DFAR really only adds, to each one 4 things. You've got the timeline kind of clarifications, and you've got the guidance regarding performance when you're talking about protests, and then you've got that limitation on certain decisions made to control disclosure of information and mitigation of supply chain risk in IT procurements. Those are kind of the big headline items, or really the only items when you're talking about DFAR nuances relating to protests. And then the claims, you're talking about these additional or supplemental clauses, some additional reporting, and the fact that the contracting officer's going to look back at your history when talking about your claim. And then you've got basically just incorporation of the limitations on payment stuff. But the way that these work, you've got to understand these in conjunction with the FAR, in conjunction with the regular forum rules and the Contract Disputes Act. And if you have a handle on all of that, you're going to be able to navigate both in the protest world and in the claims world very, very well. But of course, there's a lot going on in these areas. It's a tricky legal, nuanced area to be in. So if you have any questions, you can feel free to reach out to me on this topic or any other legal topic. Again, my name is Maria Panicelli. I'm a partner at McCarter & English. You've got my email there. With that, happy to turn it back over to my lovely host. Thank you very much, Jennifer Souse, for hosting. Thank you to all of you out there for attending, and I hope to hear from you or see you at Jen's event later this month.
Maria, that was excellent as always. We love having you on the program. So thank you for taking the time not only to put together the great slides, but sharing your time with us today and just making everything clear and concise and keeping it in a fun, upbeat manner. We love having you. So thanks. Everybody, you've got Maria's contact information here. I'm gonna remind you that you can subscribe to our YouTube channel. It doesn't cost you anything. All of our videos are absolutely free. You'll be alerted to any uploads on the YouTube channel, and this video will be up in, let's say, in the next probably 2 or 3 hours. In the event that you're watching this on YouTube, give us a like, leave a comment. We would love to hear from you. And just another reminder on the event, June 23rd in Washington, D.C. You've got the confirmed federal government departments and agencies here. We expect about 250 to 300 plus government contractors in the room. You can click on the link that's on this screen to buy a ticket. Ticket prices do go up tonight, so make sure you snag your ticket before 10 o'clock. That's it, and we'll pick up next week on Wednesday and Friday as we continue with DFARS Part 234 and 235. And again, thanks, Maria. Thanks to everybody who joined us.
Thanks.